Good morning, everyone. I'm Jim Houlihan. I'm a partner at Schoeneck King, and I'm here this morning with my colleague Bethany Centrone to talk about addressing transgender issues in New York. For those of you in Western New York, you are all like the Postal Service. Neither snow, nor rain, nor heat, nor gloom of night has kept you from your appointed rounds. So we appreciate you're here. It was a little bit of a struggle for us to set this up, but that's the nice thing about webinars. You don't have to be in any particular location to participate. So we're happy to be here this morning. There are a lot of things to talk about, and certainly more unanswered questions than answered questions with respect to addressing transgender issues in New York. What we're going to try and cover in this webinar is an overview of the legal requirements and best practices as we understand them now for accommodating transgendered employees. We're also going to talk a little bit about the legal issues regarding how public accommodations have to respond to and accommodate transgendered participants or customers. And finally, we anticipate that as the most recent regulations of the New York State Division of Human Rights are implemented and inevitably produce disputes and issues that are going to have to be resolved in litigation, we're going to try and give you some practical advice for minimizing the risk of conflicts as you implement these regulations so that you can avoid a complaint before the New York State Division of Human Rights or perhaps litigation in the New York courts. Accommodating transgendered employees raises a number of issues. Let's see if the Transgender Law Center approximates that between 2 and 5% of the population is transgender. And accommodating transgender employees raises confusing questions. Even people that are right-minded and are willing to comply with these regulations are going to have questions about the best way to implement the regulations accommodating transgender employees, but also addressing legitimate concerns or concerns of other persons affected by that accommodation. The important thing that everyone needs to understand is as of 1/20/2016, the Division of Human Rights has adopted regulations that prohibit discrimination based upon gender identity, and they've done that by saying that discrimination based on gender identity is a form of sex discrimination. The details of the revised regulations, which are very short but essentially address every aspect of the New York Human Rights Law. It extends the protection of the law in various areas to those people who are transgendered. Probably one of the most important things of the new regulations is the definitions that it includes for gender identity, transgender person, and gender dysphoria. The regulations define gender identity as having or being perceived as having a gender identity, self-image, appearance, behavior, or expression, whether or not that gender identity, self-image, appearance, behavior, or expression is different from the traditionally associated with the sex assigned to that person at birth. So it's a very broad definition and essentially extends protection to anyone who perceives themselves and identifies themselves as having a gender that's different from that they were born with. Discrimination based on gender identity is sex discrimination. The regulations also define a transgender person as an individual who has a gender identity different from the sex assigned to him or her at birth. And finally, the regulations also define gender dysphoria, and they specifically define gender dysphoria as a protected disability and say that describe it as a medical condition related to an individual having a gender identity different from the sex assigned to him or her at birth. So, with respect to gender identity, transgender person, gender dysphoria, discrimination on any of those bases is sex discrimination under the New York Human Rights Law, at least according to these regulations.
Jim?
Yeah,
I think it's important to note that not everyone who may be transgendered necessarily has gender dysphoria. So in thinking about whether this is an issue with that's pure sex discrimination or maybe disability discrimination, there may be some questions that have to be asked as far as whether the person needs an accommodation for disability or whether they actually have gender dysphoria.
Right, and the important distinction there is that a person who has gender dysphoria is entitled to reasonable accommodation of that medical condition. The law extends beyond just purely non-discrimination on that basis to providing a reasonable accommodation. Thank you, Bethany.
You're welcome.
And in terms of the new regulations, obviously they prohibit discrimination in employment, but as we just said, they require reasonable accommodation of medical conditions, including now gender dysphoria, prohibit discrimination in places of public accommodation. Bethany will be talking about one of the hot topics or the flash topics, things that tend to upset people, and that is the use of restrooms in places of public accommodation by transgender individuals. But the law also prohibits discrimination in housing against, based on a person's gender identity, their transgender status, or gender dysphoria. And, the regulations have not provided specific guidelines, which means in many cases the Division of Human Rights or the New York courts are going to have to provide those guidelines as disputes under these new regulations make their way through the administrative process for determining claims before the New York State Division of Human Rights or work their way through the litigation process in New York courts.
So, although there are no specific guidelines under the new state regulations, there are significant trends in other areas that can help inform what we might want to do. I mean, in the most basic sense, with regards to someone who might be transgender but might not have gone through the process of changing their actual gender physically, you're not discriminating against somebody because you have a male person requiring them to use the men's restroom, but with looking at guidance and case law or cases that have come through the EEOC, it's clear that other agencies have determined that the gender of the person who may be transgendered is the gender of choice. So the trends over the last few years, in 2012, the EEOC issued a strategic enforcement plan which included sexual orientation and gender identity under sex discrimination under Title VII. And the EEOC has been enforcing that quite a bit. Just last month, the EEOC settled a case with a Minnesota company where the company had to pay $115,000 plus $40,000 in attorney's fees based upon transgender discrimination. And in that case, there was situations where the employer would not allow the employee to use the restroom of the gender of preference. And also there was harassment, including epithets, refusal to use the pronoun of the gender of identity, and those types of things. The EEOC's enforcement guidance can be found here, and we would recommend that those of you would go to this and take a look at what the EEOC is saying. Now, these the EEOC's trends have not yet been disputed in the courts or at a higher level in the court, so it's certainly possible that at some point in the future someone might say, you know, a court might hold that gender identity isn't sex discrimination under the statute at the federal level. However, now that we have the regulations at the state level, we still have to consider how this might be interpreted. In July of 2014, a presidential executive order added gender identity to protected categories for federal procurement contracts. So if you're a business that contracts with the federal government, this is something that you've already had to consider with regards to affirmative action plans and non-discrimination in federal contractors. And we've got at least 18 states in Washington, D.C. now that have laws protecting gender identity. So it is expanding throughout the country. So how do we, under these new regulations under New York State law, what do? All we know from the law is that we can't discriminate against individuals based upon that gender identity and have to accommodate individuals with gender dysphoria and cannot discriminate against them because of that medical condition. It doesn't tell us specifically what we do when someone with a transgender person seeks to use the bathroom of not of their physical gender or has other accommodation issues that are related to their gender of choice as opposed to their gender of birth. Where we kind of look for guidance is in New York City. New York City has recognized the preference or the gender identity discrimination since 2002. And under the New York City regulations, under the New York City human rights law, the preference of the employee controls. And that also seems to be the trend in other enforcement agencies. The EEOC seems to move to that trend. And in guidance for the Office of Personnel Management, they suggest that the employers that are within the federal government use the employee's gender of preference to determine how they might respond to issues that come up. Now, under the New York City regulations and the New York City human rights law, within that jurisdiction, employers cannot require transgendered individuals to use a restroom of their biological sex. They cannot require an individual to provide medical documentation or other proof of a physical transition. You know, with that in mind, there's a lot of discussion about the fact that there may be people who are transgendered that are in different stages of that, or who cannot afford to have the surgery done to physically change themselves to their gender of identity, but that doesn't mean that they should not be treated as their gender of identity. Also, it's unlawful not to use the individual's preferred name as a transgender person or pronoun, regardless of their biological sex. And you can see this in a lot of the case law or the agency decisions, where especially the intentional use of the biological gender or the birth name is seen as harassment of individuals who are transgendered. Also, it's unlawful under New York City law to refuse to allow individuals to participate in programs or activities that are based upon biological gender because they are not biologically the gender of that activity. I think if you have an organization, there's different uniforms for male and female employees, or there are activities that you might do that are gender-based. You know, obviously they would have to comply with the non-discrimination requirements of the law to begin with. But if there are those types of situations, you would want to have the employee that's transgender to be able to participate based upon their gender identity, not on their biological gender. Now, under the New York City statute, it specifically prohibits dress codes that are based upon gender. This is one area that I don't see other jurisdictions following. You can have gender-specific dress codes, so female employees have to wear skirts, male employees have to wear ties, depending on what is appropriate for your company. But you would, I think, the safest thing to do to avoid a complaint would be to allow the transgender individual to dress pursuant to their gender identity as opposed to their biological gender. Again, the Office of Personnel Management has developed, and the Federal Office of Personnel Management is basically human resources for the federal government, and they have developed some very good reference materials for their policies regarding employment of transgendered work individuals. And again, this is a place where you can go to look to see how it is, how they will review and look at these situations where you have transgendered employees. And I think that, you know, from the standpoint of defending yourself against an EEOC complaint, especially, following these guidelines would certainly be to your benefit, in the sense that these are the guidelines that the EEOC, as employers of federal employees, would be applying. So we have a hypothetical, and the hypothetical that we have is one that's likely to create the most issues for employers, in the sense that if you have an employee that comes in that is already transgendered and is not known to your workforce and is one gender and moves to another, they're less likely to create a stir, and frankly, maybe some of your employees wouldn't know that that employee was transgendered if they came in based upon their gender of identity. However, when you have a known employee that's been around for a while that may change genders in the workplace, it's more likely to cause a stir within your workforce and be noticed, obviously. So we have Jason, who's worked for a manufacturing company for 10 years. He's always been a good employee with good attendance, no discipline. And Jason asks to meet with his HR manager and informs her that he's going through a gender transition. He lets her know that he has been dressing as a woman at home for months, and that his next step in her therapy, now that she's transitioning, is to present as a woman at work, and plans to start in a few weeks.
Bethany, before we move on in the hypothetical, I want to thank everybody for all the questions that you're giving to us. We're going to review them at the end of this hypothetical, because some of the things that you're asking may be addressed by the presentation. Others will address at the end of this hypothetical. Thanks, Bethany.
You're welcome.
You can go on.
Yep. So in this case, it's great that Jason has asked her HR manager and talked to them ahead of time, as opposed to just coming into work as a different gender all of a sudden, so that things can be worked out more smoothly. We hope that all of our employees would possibly do that. So Jason asks to have all of her employment records changed to reflect her new name, which she now wants to go by Janet. She wants a new company ID badge with a new picture and name. And then she also wants to begin using the female restroom. So the company that Janet works for is a very traditional manufacturing environment in a conservative community. And Donna, the HR manager's reaction is that she's very concerned about how the other employees are going to react. She wants to issue a memo to all employees. She considers conducting training, but she consults with the plant manager, who just wants to ignore it, basically, and thinks that drawing attention to it will make it worse. She listens to the plant manager, doesn't say anything, and leaves it up to Janet to tell others if they have questions. All she says is talk to Jason, which she should say talk to Janet, I guess, at this point. So after Janet begins to use the restroom, another female employee complains that she doesn't feel comfortable. And then a few months later, Janet requests FMLA leave for sex reassignment surgery. And here's where we start to get into the areas of conflict and issues that can become problematic when interests of some of your employees directly conflict with the interests of the protected employee, who now is Janet. So what's the best practice?
Yeah, Bethany, one of the first questions we have has to do with the name change issue. The question is, aren't we required to use an individual's legal name for their payroll, taxes, and other legal purposes? I noticed that you started to use the female pronoun, you know, transitioning from Jason to Janet. What are the rules in that area? You know, and maybe you can divide it in from the legal perspective, things like payroll and things that have legal import, and then talk about the practical aspect, you know, in terms of how you refer to the individual.
So we'll skip ahead and then we'll go back to the restroom issues. I think name changes, I mean, if we think about it, name changes aren't unique to transgendered employees, right? So to a certain extent, we want to respond to Janet's request the same as any other request for a name change. But I would have the caveat that if we I do know of employers that have very strict guidelines with regards to names and how they appear, especially in email or in on name badges, and that's just because the processes used are better for that, or you know, you use your first name and last name for your email address, and the system isn't that accommodating to differences. So if that's the case, you may want to consider altering those very specific process rules so that you can use the preferred name. But I think appropriateness of asking for proof of a legal name change depends on the type of request, just as was alluded to in the question. Certainly official government documents like I-9s and payroll and W-2s would need to continue to have the legal name of the employee. So an employee wants to be called Janet. That's there doesn't seem to be any reason not to allow this. It's really no different than an employee named Mike asking to be called Mike, only asking to be called Mike, or some employees go by their middle name in communications or a nickname. So it wouldn't seem that we should treat Janet any different because she wants to be called something other than her actual name. That's legal name. Again, the name new badge, again, we wouldn't think that a legal name change would be required. There may be some policy changes or exceptions that you might need to make based upon your company's policy with regards to how names appear on badges. Sometimes name badges will have the full proper name and then a larger nickname on a badge. You know, in cases like that, you may want to not use the full proper name or legal name, in the sense that that would alert everyone that Janet is a transgendered individual and potentially open her up to harassment or other ill treatment. Again, my paycheck should be changed. IRS requires that the W-2s and the W-4s match Social Security cards. Therefore, in order for you to make that change in those records, the Social Security card would have to reflect the change in the name. And again, you want to make sure that you're treating Janet the same as other employees. So if you have an employee that gets married and wants to change his or her name due to the marriage, you should make sure that you are asking them to provide a new Social Security card that matches their new name at the time that the name change is made in the system, just like you were asking Janet to provide the name change.
Bethany, what happens, we've now, the general guidance is to allow Jason to request and abide by his request to now be referred to as Janet. What if someone out in the shop just wants to be referred to as, some other name, just a fun name or something that that person identifies with, Superman or something like that. How do you deal with that? I mean, especially if it's not based and not grounded in any request for accommodation of any sort.
Well, I think that it would depend on why the individual was asking for the change. I mean, I think that if my name is Bethany Ann, and if I decide that I like Ann better than Bethany and want to go by Ann, I think that that's something that if you why argue about it in some respects, but also I think that whether you have to do it or whether you should to reduce legal risk is going to depend on why. There are other protected categories that might initiate a name change. Somebody changes religions, those types of things. And if it's based on a protected category, I think that it would be a good idea at least to check with legal counsel to see whether or not that's something that should be accommodated or has to be accommodated, as opposed to something that's an employer decision to make.
Yeah, this reminds me of the recent guidance that the EEOC has given on dealing with religious discrimination and accommodation, because that guidance clearly says that simply because you need to make a particular accommodation for an employee because of their religious observance or religious beliefs, that doesn't mean that you have to make that same accommodation to someone who doesn't have that religious underpinning for the request. Mm-hmm. So what it may mean is that you're going to have some wisdom discerning, as you said, between legitimate reasons for making the request by a person who's not protected by these new regulations, and making a wise choice between that which is reasonable and related to a legitimate concern and that which is not.
Mm-hmm. Yep, and I think one of the other areas that are that when you bring up the religious accommodation and religious discrimination, this is an area that has been, at least in one court, not in New York, but has been raised with regards to the transgendered, accommodating transgendered employees. So when we think about what are we going to do when we have a transgendered employee that wants to use the restroom of their identity as opposed to their actual physical gender, and the other employees are unhappy about that and they complain. I think that hopefully and I think that from at least looking at case law where this has come up, typically the transgendered employees are willing to have conversations with employers about how they're going to transition in the workforce, and hopefully that is going to be all of our experiences. But I think that's a time to have conversations with your employees about restroom issues. It's going to depend on your structure, your physical structure of your facility. You may be an employer that has single-use restrooms and it's not an issue. If you're considering construction with regards to, and changes with regards to restrooms, we would recommend that you think about this piece of the new law before making changes and creating single-use restrooms or single or non-gendered restrooms, because that would take away the issue. But we would recommend that we not force our transgendered employees to travel long distances or to have situations where it's going to be difficult for them to use a restroom. For example, in a case involving civilian employees in the military that the EEOC found for the employee and awarded $150,000 to that employee, The employee originally indicated that she was willing to use a single-use restroom and not the ladies' room, which was her gender of identity, although she was physically male. But that restroom was frequently out of order, and it became very inconvenient for her to be able to use the restroom, and later changed her mind because of that inconvenience. And the EEOC cited that piece of it as part of the reasons why it ruled in her favor. Other reasons included the fact that she was being harassed by fellow employees in the workplace, and that they would consistently use the male pronoun when referring to her, and they would consistently use her male legal name as opposed to the female name that she had selected. But in a case where it has been raised that an employee sued a biologically female employee sued her employer because she did not feel comfortable sharing a restroom with a biological man presenting as a woman, and filed this lawsuit under religious and gender discrimination statutes, and this was in Minnesota. That court dismissed the complaint, indicating that it did not rise to the level of an adverse employment action, and it didn't create a hostile work environment. We don't know at this point how this is going to play out nationwide. I think that it's certainly possible. The Supreme Court has gotten more conservative with regards to religious accommodation issues, and that they are finding more and more, expanding more and more with regards to what requires accommodation from a religious freedom perspective. So this is something that we will want to look at, and this is why I think that as you have the opportunities to go forward and eliminate this issue by changing how your restrooms are organized, for lack of a better word, you can sort of avoid this issue potentially in the future.
Bethany, I know I kind of put you off the pace there and got out of order here in terms of the presentation. So while you're getting us back on track, I'm going to address a question that was posed early on in the session. And the question is, do we have a duty to accommodate gender dysphoria, and what does that mean? Can provide an example of an accommodation that might need to be made for someone with gender dysphoria? Well, gender dysphoria by the new regulations is defined as a medical condition. So the obvious response would be that if a person requires time off for doctor's visits, for counseling, for any type of treatment related to gender dysphoria, you would have to make a reasonable attempt to accommodate those absences. Furthermore, generally, if someone has gender dysphoria and decides to at least pursue gender reassignment surgery, that is a long process that often requires a year living life as the gender to which they most identify. So it also requires hormone treatments and a variety of other things. So all those issues could conflict with a work schedule or the demands of a particular job, and so those would be examples where in the employment setting you might be asked to accommodate gender dysphoria. And quite honestly, I think we've only begun to think of the ways these issues might be raised. It's going to require, as Bethany said, some guidance from the courts about how to balance these issues and do so in a way that addresses the legal constraints that these regulations impose with the practical constraints of a diverse workforce.
Certainly, certainly. And I think that part of this webinar is to try to give you some tools to be able to address these issues if they arise. And I think that the biggest thing is to try to have some kind of plan and an idea of what what you will be doing if you have an employee that comes to you with indicating that they're transgendered. So I think communication is key in this situation. I think that at the beginning we talked about Donna wishing to put a memo out or be more open with the communications, and the plant managers wanting to push it under the rug. And I think that the HR managers' instincts in that situation were much better than the plant managers. Certainly a message of support or warning of violations of discrimination policies and gender discrimination policies would, from the company, would help reduce the likelihood that there will be backlash from employees in the general employee population. Also, there's nothing better than a good story in a lot of workplaces. So having it out in the open as much as possible with a communication plan developed with the transgendered employee will help quiet the rumor mill and try to set a positive tone. I think it's important to try to work with the transgendered employee to develop that communication plan. We don't want to be in this situation where the allegation against the employer is, well, they told everybody and I didn't want them to be told, and that's why everybody started harassing me once they found out. Certainly if it is a medical condition, if someone does say that they have gender dysphoria, nothing regarding the employee's medical conditions, or if they're having surgery or discussing the fact that they're going to have surgery with others outside of the employee would be appropriate. But I think that you would want to be able to, if possible, with the consent of the transgendered employee, talk to the people that are in the in the immediate work team of the employee that's going through the transition, and try to develop a plan of how you're going to address issues if they come up.
Bethany, we've gotten a number of other good questions, but one thing I want to suggest to you and see if you agree. Mm-hmm. I think that the first order of business for any of you that are in the HR field should be to prepare training for your executives and then your supervisors, because they may not be as attuned to some of these changes in the law and the regulations as we are in the labor and employment field, and some of these changes may seem very almost surreal to them, and I think that the best thing to do is to begin to inform them about the change in the law. If necessary, inform them about the potential consequences of violating the law. Certainly one of those consequences is, I surely hope that none of our clients are part of the cases that end up defining the parameters of these prohibitions. I would like to at least ensure that all our clients have updated their policies, have a management team that understands, if not supports, the changes and is prepared to abide by them. So I think the first order of business is to, as HR representatives, is to start educating your management team, because that makes the rest of the implementation that much more impactful. Bethany, let me ask you a question. There's an interesting question here from someone that provides home care. The question is, the badges of the individuals that go into person's home and provide care that are licensed either as personal care aides or nurses. The question is whether the name on their badge has to reflect the name on their license or their certificate. Any thoughts on that?
I think that's a good question. I think that the names on the badges are based on company policy. in the first instance.
In this case, in this case, the suggestion is that maybe the state regulations regarding licensing may impose a requirement that the badges reflect the name of the licensed individual.
Right, and I think that that may be, that may be something in that situation. Obviously, you want to have your clients and patients to be able to ensure that whoever's walking into their home is licensed. And so that would be maybe a legitimate business reason not to alter your policies to allow an ID badge to reflect the gender preference name as opposed to the legal name. And that it would be up to the employee to work with the state licensing department to see if they can get an alternate name for their license. And there are steps that people can take to have, I mean, it's even possible to have your birth certificate changed in some states, after surgery, to have your birth certificate changed from one gender to the other if you have gender transition surgery. So I think that, from my perspective, and we haven't gotten more than a month past the enactment of the regulations, but that would be a reasonable basis for not changing the name on the tag. I think the more difficult situation arises when the client or patient indicates that they refuse to allow the transgendered person to provide services to them.
Yeah, that is the tougher question, because customer preference has never been a defense to complying with the law. So back in the early days of the civil rights movement, the courts rejected the notion that simply because your customers did not want you to serve persons who were African American, or that was not a legitimate defense to complying with the law. And I don't see any difference in this setting. I expect the courts would say that you're required to comply with the law regardless of customer preference. Do you agree, Bethany?
I think so. I mean, unless we get to the point where the courts say that the law, the regulations improperly expand on the law, either under the state, the EEOC's enforcement of Title VII, or the state regulations that were passed in New York. But those are issues that are going to be out there for a long time, I think, until for those that do not want to comply, until that gets through the courts to find out who's right. So we talked about name changes. Again, I think, Jim, you touched upon the FMLA issues. I think that, if an employee has gender dysphoria or is going through surgery or any kind of therapy or counseling, if they meet the definition of serious health condition under the FMLA, I think, that they would be entitled to FMLA leave.
Right, I think most likely they would fit the continuing treatment definition, depending on the extent of their medical condition.
It is. It may be unclear under the federal, at least under the federal law for under Title VII or the ADA. Transgendered status is specifically excluded from the definition of disability under the federal law. And my guess is, I'm not 100% sure on this, but I think that part of that is because I think that individuals didn't want to be seen as disabled because they might be transgendered. But that may bleed into FMLA enforcement. I haven't seen any cases that relate to it at this point, but under the state law, you're going to have to accommodate individuals with disabilities and probably give them the leave anyway. So assigning it and identifying it as FMLA leave is really going to benefit you because it allows you to use up the FMLA time at the same time as you're accommodating the employee under the state law. Again, we touched on this earlier, dress codes. Outside of New York City, dress codes that differ between men and women, or male employees and female employees, are generally accepted. Again, we would recommend that if you had a transgendered employee, that you allow that employee to follow the dress code that is associated with their gender of identity as opposed to their gender of their physical gender.
Bethany, we've got a few minutes left here. I'm gonna, before you head into these last couple of slides, question from one of the participants: how do you discipline coworkers that have received sensitivity training on the topic of gender identity and still decide not to call an employee by the preferred gender name or have religious reasons not to recognize the gender of choice and use the correct pronoun? Well, I think that's going to depend on what process you have in place for enforcing other work rules. I think that if you first have a policy that's consistent with the new New York regulations and prohibits discrimination based on gender identity, transgender status, or gender dysphoria, then I know it's easy to say, but then you have to follow your policy for administering discipline, and normally that would include some form of progressive discipline, such as verbal warnings, written warnings, suspension, and then ultimately termination. I think if you ask this question and then change, gender identity to race or national origin or religion, I think the answer would be a little more obvious, that we need to follow through and enforce our policies prohibiting race discrimination, national origin discrimination, religious discrimination. Now we have to add to that list gender identity, transgender status, and gender dysphoria. So I know that it's easier said than done, but I would make sure that that you apply your current work rules for enforcing, the current policy for enforcing work rules, and not stray too much from it, because if you follow your policy closely, you're going to have fewer problems in terms of reverse discrimination claims, if you will. So I don't know if that's that may not be helpful, but I think that's the best answer I have for you. This next question might take us into the final couple slides. The question is, can a public institution refuse to use a preferred name in its records without evidence of a legal name change? And I think we may have covered some of that, but I think that may take us into these last couple slides here, Bethany.
Sure, and the state law, the new regulations, the state law has always prohibited discrimination against protected status for public accommodations, and now that transgendered status and gendered identity is protected, the state law prohibits public accommodations to discriminate against transgendered individuals. And I'm not going to read this list of all of the things that are within the definition of public accommodations under the state law. Suffice it to say that if you are open to the public and provide services to the public, you are a public accommodation. If you have specific questions about whether you fall into that, certainly private clubs where membership may be required potentially could not be included public accommodations, but I would definitely check with your attorneys before assuming that you're not. So what should you do as a public accommodation? I think that certainly you want to get ahead of any issues. I think that this is a very I can remember in college and working in a fast food restaurant and having someone who appeared to be transgendered come and, we were all 19 or 20 years old and giggling our heads off because someone came in that we thought was probably male and was dressed in female clothing. So you want to make sure it wasn't unlawful then, and we served the person as best we could, but you want to make sure that you're training your employees and having policies and protocols in place to address appropriate responses to should a transgendered individual require service or request service. You want, in any situation, you certainly want to ensure that your staff is trained regarding their non-discrimination obligations.
Hey, Bethany, this slide goes right into one of the pending questions. Great question. How would an employee necessarily know what pronoun an individual prefers to use, especially in the situation where the individual hasn't physically changed genders or hasn't started that process or changed their names? And I think the key thing is once you train your management team, I think by letting your employees know that the law has changed and that gender identity, transgender status, and gender dysphoria are now protected, that would make it easier for someone to come forward to HR or someone that person trusts in a managerial position and discuss these issues. So I think some of those concerns, those practical concerns, might go away once everyone understands that there's protection here. But certainly I think there is, as you pointed out from the hypothetical, Bethany, there is a duty on the transgendered individual's part to be somewhat assertive in this situation and advise the employer, or if it's a place of public accommodation, how they would like to be treated and what they would would like to have the employer or place of public accommodation do.
I think that, especially with public accommodations, there are businesses that someone will walk into and be there for, a one-time, the restaurant situation where somebody walks in. You may not even know that the person in front of you is transgendered. You just know that they present as a man or they present as a woman, and obviously that's not going to create an issue. When you have businesses that have more of an ongoing relationship where that type of information may be revealed, certainly that's when you want to have that dialogue with your customer to determine how to best serve that person on a go-forward basis. Certainly you can't refuse service, but if you're going to have a long-term relationship with a customer or client that's transgendered, how do you address issues that might come up? And in situations where it appears obvious that somebody is transgender, then we just need to make sure that our employees are sensitive and professional, with those situations. And I think that one of the best things that we can do is that if there's a conflict, how can we confidentially and promptly address those, as quickly as possible. I think there's probably a number of different types of accommodations that this could be an issue for, such as spas, any place where there's changing rooms or, again, restrooms that are open to on a gender basis. So I think that, again, having the process and protocols ahead of time is the best way to try to reduce the likelihood of conflict when things might occur. Because if somebody walks into a locker room that happens to be transgendered and you don't have a way to address that, it's more likely to get out of control than if you have something in place ahead of time.
All right, we've only got a few minutes left. Bethany, why don't you address the housing issues, and then we'll try and answer or respond to as many questions as we can.
And the housing I bring up mostly because there is nursing homes and other places where there might be businesses that are not public accommodations necessarily, but would fall under the housing umbrella. You may have an apartment building. People may be unhappy with having a transgendered person living in an apartment building, and just to know that just as you can't discriminate against individuals because of their race in housing, you wouldn't be able to preclude a transgendered individual from purchasing a home in an area or living in a building or potentially in, again, a nursing home just because they happen to be transgendered. And I think that in some cases this is where people are closer together in living space, maybe the areas where more conflict could arise in the future. So we just want to make sure that those of our clients and friends that are out there that may have this potential issue are aware that this could be problematic in the future.
Question, for any forms that ask for male or female, what term would be appropriate for someone who identifies as transgender? Well, I think that probably the only forms that I can think of where that probably wouldn't be a problem might be medical type forms. Mm-hmm. I would be concerned, especially in light of these new regulations, to have that question about gender on an application any longer unless gender was a bona fide occupational qualification. Right. The law does recognize there are certain jobs that require a male or female, and they generally have to do with situations where someone's providing personal care to another individual. I don't know what these new regulations are going to do to that concept of bona fide occupational qualification. In fact, our prior discussion about the home aid might be addressed by that whole analysis of bona fide occupational qualification, but there's certainly going to be twists on that analysis moving forward. So I think, Bethany, if there's a medical form and it asks for male or female, how would you guide this person in terms of advising someone how to fill that form out who might be in the middle of a transition or be transgendered?
I think that with medical forms that we would want our employees or clients, or if it's in an office, to fill out the form accurately based upon biological gender. Obviously, your gender can affect how you're treated. A medical condition might be treated, and medical forms are highly confidential anyway. So having them complete accurately medical forms, I think, should not be an invasion of privacy for the individual, because that type of information is kept confidential either under HIPAA if you're a medical provider, or in an employment context under the ADA.
Well, in whatever time we have left, I thank you for all your questions, and I'm going to apologize in advance. We're probably not going to be able to answer all of them, but here's a question. So you're saying that the protected class of gender identity is above the protected class of religious beliefs when it comes to discrimination? No, I don't think that's what we are saying. What we're recognizing, and some of our comments have recognized, is that there are going to be individuals who may oppose these new regulations on religious grounds, on other legitimate grounds, and I think in the employment context, the employer is going to be in the middle of those controversies. The best thing we can do, I think, is to educate about what the current state of the law is, and until these regulations are challenged in court or otherwise limited, that is the law in New York for all employers who have at least 4 employees. So, there are going to be situations that occur when you're going to be asked as an employer to balance the rights of individuals who oppose this extension of the law with the rights of the individuals who are protected by it. I think the best thing we can do is be informed, be informed, be knowledgeable about this, consult with your counsel so that you get detailed, specific advice about a particular circumstance, and then watch for the evolving changes in the law. Certainly I would suggest that you monitor the Bond Labor and Employment blog, because we certainly will be covering this. So let me move on to a couple last questions here. What about a requirement for businesses to provide facilities for folks who are offended by being in an open locker room with biologically opposite gender? Okay, so this certainly, for those businesses perhaps that have employees who have to change into work clothes, or who simply provide locker rooms and showers for people to change after work because they're dirty or have chemicals on them. Bethany, I'm going to punt this one to you. What's your advice for an employer who's in that situation that has the real practical problem of accommodating a transgender individual, but also making sure that their employees have access to locker room facilities?
You know, I think these are some of the hardest questions. It comes up a lot in education, because there are regulations under education law that require accommodation of transgender students. You know, I hate to say I'm not 100% sure, but that's really where we are. I think there's a push from the transgendered community to fully incorporate a transgendered individual in all ways, including locker rooms, without any kind of separation. And obviously that's very uncomfortable for a lot of people that might be in those locker rooms. I think that, you know, as we move forward with this, we want to try to devise solutions that may help us avoid the questions of these problems. So, for example, in locker rooms, you could have curtained areas where people could change in private if they felt uncomfortable. You know, some transgendered individuals might be uncomfortable changing in front of other individuals that are biologically their preferred gender. So I think as this area of law develops, we will probably see more and more employers and public accommodations move towards gender-neutral facilities where people can maintain privacy regardless of what their gender is. But it is a difficult situation. I would recommend that we try to, as much as possible, you know, create situations that are where we can accommodate the privacy of both individuals. Again, in the locker room with curtains, private locker rooms if possible, rooms to change, those types of things.
Well, we're going to wrap this session up. We thank you for participating. For those of you who had questions that we weren't able to get to, I can assure you we're going to keep track of those questions. I feel that this is a presentation we're going to have to give periodically as the case law and decisions at the New York State Division of Human Rights are issued. And we certainly will try and address the questions that we didn't get to, as well as those that we did, in any future presentation. So for Bethany Centrone and Bon Schoeneck King, this is Jim Houlihan. Thank you for your time this morning.
Thank you, everyone.